Okay, good morning, and thank you all for joining us today for this very special presentation of our ongoing series of Kirby online health and wellness presentations, special considerations for service by special considerations by seniors by Servus Credit Union. And as we gather here today, it's vital we also remember the peoples who've gathered here for millennia. This is the Treaty 7 land of the Indigenous peoples of Southern Alberta, the Blackfoot Nations of Siksika, Piikani, Kainai, Tsuut'ina First Nation, the Stoney Nakoda Nations of Chiniki, Bearspaw and Wesley, and the historic home of the Northwest Métis and Métis Nation of Alberta, Region 3. It is with the goal of reconciliation that we acknowledge the land on which we gather, and we thank the elders of these nations for their timeless contributions to this land. First, I'd like to begin by thanking Servus Credit Union, longtime supporters of Kirby Centre, for their very generous sponsorship of many of our upcoming Kirby Centre online presentations. We look forward to working with you throughout 2021. And today we're pleased to have Stephanie Greenow, Jeff McKenzie, Katrina Roth, and Shirley Surdhauer joining us from Servus Credit Union. Stephanie joined Servus Credit Union in 2017 and currently works as an investment specialist. Stephanie is a certified financial planner and focuses on holistic financial planning. She strongly believes that personal finance is personal. There is no one-size-fits-all investment strategy. Stephanie prioritizes financial literacy and education to ensure her members feel good about their plan and their money. Thank you so much for joining us today. Stephanie, as we have been dealing with an uncertain economic environment for some time now, and tax time is right around the corner, what can we do to protect our estates and financial future as seniors?
Awesome. Thanks so much, Colleen. I hope everyone can hear me okay. And Katrina in the background is going to get working on sharing some slides here. First off, I just wanted to thank the Kirby Centre for inviting us to present here today. We're really excited to be here. We wish we could see you all in person, but we understand the times that we're in, so we just hope that you're all keeping safe and well, and hope to see you in real life sometime soon. So for those who aren't familiar with Servus, I'll just give you a little bit of background. We are a full service financial institution. So we offer all of the things that you would come to expect from a traditional bank, whether that's daily banking, loans and mortgages, investments. But we offer a few benefits that you wouldn't find at a traditional bank. We're a member-owned financial institution. So if you are working with us, you are a part owner of Servus Credit Union. And that comes with some benefits, including profit share. So every year we share our profits back with our members. And then we also offer 100% deposit guarantee on our GICs and savings accounts. So a little bit better coverage than you'd find at the traditional banks. Specifically here today, I'm part of the wealth team here in Calgary. So that's the lovely group that you're looking at there on the screen. I'm lucky to be joined today with Katrina Roth, who's one of our investment advisors, Jeff McKenzie, who's our wealth protection specialist, and Shirley, who is our estate and trust specialist. Katrina, if you want to flip to the next slide there, just a little bit of background as well on what the wealth team specifically does. We really do focus on holistic financial planning with our members. So my title is investment specialist, but when I'm working with you, investments in and of themselves, there's so many other things to be considered. So we do look at all 6 pillars of financial planning, whether that's debt management, cash flow management, planning for retirement, and many of you are probably already retired, but looking at making sure that you're going to be okay in retirement, financially speaking. Tax planning, making sure that any recommendations we do provide are the most tax efficient option possible. Risk management, so making sure that if something unexpected happens, that you're protected. And then estate planning and legacy planning. This is certainly important, and this is what we're going to be focusing on today. We had a lot of different topics that we wanted to discuss with you, but we had to reel it in. And so today, Shirley is going to speak to estate planning specifically. But we do hope to chat with you again in the future about other topics. And if you'd like to connect with us, please let us know. We'll provide you with some instruction on how to do that at the end of this presentation. So with that, I'll just tell you a little bit about Shirley. She joined Servus in 2015. She's got over 30 years experience in the financial industry. She's been an advisor, compliance officer, manager, director of insurance, and regional director of long-term care insurance. Shirley carries her passion for helping people into the estate and trust role. She's successfully completed and holds various licenses, has her branch managers and officers and partners designation, ACS and QAFP designations. Shirley is also currently working toward her TEP, Trust Estate Planning designation. So I think you'll find a lot of value in what Shirley has to share today, and I'll pass it over to her.
Perfect. Thank you so much for that introduction, Stephanie, and thank you everyone for coming today. So I haven't done it this way virtually with a group, so it'll be interesting. I would ask that you keep your questions until the end because I won't be seeing them necessarily, but please, you can send them through the chat, the Q&A, and then we will address them after. So I promise we'll do that. So today, I'm going to talk about will instructions, estate planning, executor duties, dying without a will, which is intestate, the Dower Act, which is intestate, the Wills and Succession Act, which was done in 2012, and I'll go over an enduring power of attorney and personal directive. Before we move on, I want to make sure everybody can hear me okay. Are there any issues? I think we're okay? Okay. All right, we'll move on then. Okay, so why do we do a will? Why do we go through all of this? Well, we want to organize everything you've got in a tax efficient manner. You want to make sure your beneficiaries get what you want. You want to get them to the people you want. So it's when we're talking about this, it's going to lead to completing your will, your enduring power of attorney, and your personal directive. So, can everyone see that? 'Tis impossible to be sure of anything but death and taxes. That was 1716. Nothing's changed today. That's still what we're dealing with. So why is it important? Well, you want to get your assets to your beneficiaries. You don't want to rely on the government to decide who those beneficiaries are. You want to provide protection for your dependents, and it may minimize family conflict. So there's our number one estate problem right there, family conflict. Everyone says, oh, that's okay. Everyone says that, you know, everyone gets along. They do get along until there's money involved, until someone passes away. So very few times does it go smoothly. So definition of a will, a dead giveaway. So I hope somebody's laughing back there. So assets included in your estate that are going to be subject to probate. So it'll be your personal items. It'll be real estate, whether that be your home, vacation property, rental properties. Businesses that are not incorporated, incorporated businesses will follow the shareholders agreement. So any investments that you have, whether those be mutual funds, GICs, or whatever it is that you have. So what's not included in your estate, so what's not subject to probate, which means it's going to flow outside of your estate. It doesn't have to go through that long probate process. It's going to happen fairly quickly. So any joint assets with right of survivorship, so that would be things like your home. Any beneficiary designations, so on your registered plans, your RIF, your life insurance, or assets held in trust. So in a spousal situation, important to know, registered plans are going to pass to the surviving spouse as a spousal rollover. no tax implications at that time. Taxes get deferred until the last one of the two people pass away, at which time the money may be used up, could be less, and the tax rate should be lower. So that's a win-win, does not need to go through probate. So why is it important? Well, you want to distribute your assets. Do you have underage children or grandchildren that may be relying on you? What's going to happen to them? Do you have a spouse that maybe can't rely on to take care of the money properly and maybe needs a trust so it doesn't all get given away or spent? And you might need trust for your children or grandchildren. Your funeral instructions, it's important that you cover that. What do you want to happen? If you don't do that, people are just going to decide for you. So do you want to make charitable donations? Also, when you do a will, your mental capacity is really important. So you're going to, if you're in front of a lawyer, that lawyer does the will, the lawyer is attesting to your mental capacity. That's extremely important. If you do your own will, nobody's attesting to that. So when we're looking at your doing your will planning, we're going to look at your current assets, your tax situation, family circumstances and dynamics. Well, that's huge. Is it a blended family or are there kids from different marriages? What does that all look like, and different considerations depending on your situation? Your beneficiary decisions. It's important that the proper legal wording is in your will. When people do their own will, they don't have that proper legal wording. And it's really important that you're going to pick and appoint your executor or any trustees that you may have. So that's what it typically looks like. This is the family getting along. So executor duties, they are many. I can't go into all of them. It's a lot. But the first things they're going to do really is find and interpret the will and communicate with the family. But what they're looking for right away are the funeral instructions. What are they doing? And it's going to be finding all the paperwork and seeing where investments are and what they are, what they have to deal with, communicating with the beneficiaries, doing those funeral arrangements. You're going to look for insurance, and all those claims need to be completed if there is insurance. Redirect mail, the simple stuff, right, that people don't think about. If you have magazine subscriptions, they need to be canceled. You've got to protect the real estate. So what that means is often locks will be changed. That's one of the first things to do. So people don't go in who may have a key and start taking things that they want. You're going to make sure the proper insurance is on that property to protect it while it's going through probate and before it gets sold. If there's a business, you want to ensure it's able to operate in an incorporated business, that's all you can do, personal proprietor, then you're going to be dealing with liquidating that. You've got to notify everybody, the financial institutions, brokers, everybody from that paperwork you found. You've got to notify everyone of death. And then you do have to value and manage whatever the investments in real estate are. So there's a period of time before it goes through probate. So things still have to be dealt with until you're able to actually liquidate. So you're going to get probate. You're going to go to the court. You're going to start that process. You're going to advertise for the creditors. If there's safety deposit boxes, you've got to get those, close them out. You're going to pay all debts and taxes. And the big thing is preparing the income tax returns, because that can be a challenge for some people. So there's going to be a year of death tax return, a terminal death tax return, and there may be others depending on your situation. Then before you can ever do everything and get money to beneficiaries, you have to obtain a clearance certificate from the Canada Revenue Agency. Then once you've got all those things done, probate's done, you've taken care of that and many other things, you've got the clearance certificate, then you can start to distribute the estate. So that's what an executor looks like, all the things they have to do. So now we have been talking about people who have a will and the importance of doing a will. So what happens if you don't have a will? Well, then somebody's going to have to make application to the provincial court to be the executor. So that's the decision. Somebody's going to have to step up to do it. They'll make an application. It's going to take more time and it's going to cost more money to go through that process. So what happens if there's no will? The court's then going to follow the provincial formula. So everything is going to go to the spouse if the children are of that relationship. If there's children from more than one relationship, a preferential share will go to the spouse. So that'll be 150,000 or 50%, whichever is more. And then the remainder is going to go to the children. Now, in today's world, unfortunately, there can be a spouse and there can be an AIP, which is an adult interdependent partner. So in the way we think of it as someone that's common law. So if a person is married, they haven't gotten divorced, they're now living with somebody else, they're going to split that preferential share between them, and then the rest goes to the children. So the Dower Act. The Dower Act only applies if you're married. So if your spouse was the registered owner of your home, you weren't on title, and you're left a widow or widower, then you have a life estate in the home. So what that means is you don't own it, you can live there, you can't sell it or give it away, you have to pay the maintenance, the property taxes, you have to do the upkeep, but you can't leave it. If you do leave it, you forfeit the right to that home, and then it's going to go to whoever. So you can live in that home for the rest of your life, and that only applies to legally married people. It does not apply to common law. That is being looked at, however, and that could change. So I mentioned earlier that we have the Wills and Succession Act, and that changed in 2012. So every province has their own act. There isn't a uniform act throughout Canada. So if you've got a will in a different province and you move to Alberta, you need to check in with a lawyer. Chances are you're going to have to redo that will because every province has different rules and regulations. If you don't redo that will, what that means is that will would be resealed. If you move from Saskatchewan to Alberta, that will would be resealed in Alberta, and it would follow the rules of Alberta. And if there's anything different from what's in Saskatchewan, it may not be what you want. And Saskatchewan does in particular have some different rules. So with this act, if the spouses die at the same time, then assets are considered tenants in common. So what that means is married couples typically have a mirror will, which means their wishes reflect what the other one wants. They're going to be the same. So often everything to each other and then to their kids and maybe on down to the grandkids. So they're going to mirror, their wishes are going to mirror everything. However, if that's not the case, and sometimes it's not, people will have a mirror will, but it can go separate ways when it comes to beneficiaries after the spouse passes away. So if that was the case, then whatever one spouse has wanted and the other spouse wanted, it would be split. It would be considered that half would go one way and half would go the other way. Typically, it's the same, but not always. So you cannot disinherit a spouse. If you're married, it's considered you're looking after each other, you're living your life together, you're sharing it. So people do try to disinherit their spouse even when they're together. The spouse does have rights to go back to the court and claim what is theirs. So just remember, you cannot disinherit your spouse. So with the new act, marriage will no longer revoke a will. That means you have to do it. So if you don't do that, there's a 2-year gap, and after that, the spouse is automatically disinherited, but you've left yourself open for 2 years, right? So you need to go back and revisit that and do that, because if something happens to you in that 2-year period, then all the money could go to your former spouse, and that might not be what you want. So a holograph will, that used to be where it could only be in handwriting. Now it can be a mix of things, but it's still a holograph. You still don't sign or date. If you start signing, dating it, and getting witnesses, then it turns into a legal will. So with a holograph will or a will kit, the court could look at that, and they can restore a gift to a witness if they decide that the wording or whatever you've said isn't clear. So holograph wills will be accepted, but they're open to interpretation. So if it's unclear, the court will interpret the instructions, and it may not be what you wanted. If your wording was not clear, they're going to decide what it is that you meant. So when do you need to do this? You need to do it when you get married, you become separated or divorced, you begin living with somebody else, or you get new dependents, or you could acquire a major change in your financial situation, which means you need to relook at everything again. So the will is for once you've passed away. So the big thing is you're appointing your executor to deal with everything. You're putting trust conditions in there, and you're naming your beneficiaries. Now, the next two documents I'm going to talk about are for while you are still here. So the first one is your enduring power of attorney. So with this one, you're appointing somebody to manage your finances for you. And that's typically in the event, or it is in the event, that you're no longer able or capable of managing your financial affairs yourself. We recommend often that you do it with two doctors certifying that you're no longer capable before it comes into effect. But it could be immediate if you wanted. So sometimes if somebody's ill and they know that they have a shortened lifespan, they don't want to have to deal with it, and they'll make it immediate. You got to make sure it's someone you trust. You're giving a lot of power to your enduring power of attorney to handle everything, because they're going to pay your bills. They're going to manage your investments. You're going to want those things done properly. They could sell real estate if they need it to. Now, selling real estate is typically because it's needed for your care, but they do have the power to do that. Now, your personal directive. So this one is for your health. You're appointing a guardian to make decisions for your health matters when you're no longer able or capable of doing it so yourself. We, again, usually recommend two doctors signing off on this before it comes into effect, but it could be immediate if there are health issues and you just want somebody to take over. And the guardian for your health is going to make decisions for you that you're not capable of doing. So they're going to decide where you live, who you associate with, what social activities you get involved in. They'll make decisions about your life support. Should you stay on it? Are you going to do organ donation? Do you want to donate your body? How long do you want to live in your own home? Do you want alternate medicine? Do you want pain medication if you're in pain? So a multitude of things. So the person you appoint, it's important that they know what you want, because they're going to respect your wishes as much as they're able. So then another thing that we recommend doing along with the green sleeve, or along with the personal directive, is the green sleeve. So this one you do with your family doctor. It's a much bigger document. It's about 32 pages, I believe. And you can drill down on what you want to have happen in different medical circumstances. You can pick the do not resuscitate if that's what you want, and you can direct what you want your end of life care to look like. So it's an important document to do. When you do it, you put it on top of or near your refrigerator, because if the paramedics have to come, or the firemen or whatever, they know to look for it there. And one of the first things they'll look for is the do not resuscitate, if that's what you want. Otherwise, they'll do everything to prolong your life. So important to do. Now, I'm going to turn this back over, I believe, to Stephanie to introduce.
Awesome. Thanks so much, Shirley. And yeah, we're going to just have Jeff speak now. He's our wealth protection specialist for our team. So very, very experienced, many years in the financial service industry. Jeff, I'll let you take it away.
Thank you, Stephanie, for making me sound old. As mentioned, I'm the wealth protection specialist for Southern Alberta for Service. And as you can tell from the title slide, I work with insurance planning to look at different ways to enhance your legacy and protect yourself against risk. Insurance in the usual scheme of things is designed to protect your income and your family. And because of the unique features of insurance planning, there are also opportunities to increase your estate, enhance your legacy, perhaps cover off an anticipated tax bill at death, even reduce your taxable income while you're still alive. I believe we'll be having further meetings down the road where we can go into these in a little more detail, maybe do some case studies. Everybody loves a nice long insurance case study. But the basic concepts we use are the estate bond, which is a life insurance policy, takes advantage of the fact that there is no taxable income when a life insurance policy is passed on. And so it's a great way to move assets to the next generation, move them efficiently, create a larger legacy. Tax protection, if going through the planning process with Stephanie or Katrina and Shirley, we will take a look at the tax bill that we can anticipate at some point down the road when Revenue Canada swoops in on your estate. And in certain situations, we can look at an insurance plan as potentially a cost-effective way of reducing that or mitigating it or reducing the need to sell off assets that maybe your beneficiaries don't want to discard just because there's a tax bill to be paid. Another concept we use is enhancing your community, building up the assets for your designated charities or churches or things like that using life insurance products. So there are a number of things we can do. And yeah, I would encourage you, if you're interested, to reach out to Stephanie and maybe have her knock on my door if you've got a situation you want to discuss. But like I say, we will be having, I believe, a more detailed presentation on this in the future at some point in time. So I want to thank you for your time today, guys. I want to apologize for the typo I am looking at the bottom of this slide. Maybe you didn't notice it until I pointed it out. But anyways, today, and I'm going to turn this back to Stephanie.
Awesome, thanks, Jeff. That's pretty much all we had for today. So if anyone has any questions, we're happy to answer them now. There's a text box at the bottom there. And I do see a question here already from Maureen. I'll pose this question to Shirley. So the question is, can a will be partially holographic? And Maureen just notes that she is a widow, and then she made a new signed and witnessed will after her husband died. And she's asking, can I add some more directions without witnesses and attach those directions to my will? I'm thinking about such things as charitable donations or funeral arrangements.
So if we're talking about a holograph will, yes, you can do that, right? Because it's your will, it's your handwriting. There's no thing like a partial holograph will. So I did hear that at first, so I'm not sure what that meant. But yes, you can update your holograph will, but you should just redo it if you're changing things in it. And if you do witness it and sign it and all of that stuff, it turns into a legal will.
Awesome, thanks, Shirley.
Colleen had raised her hand here. Colleen, I might suggest that if you have a question, perhaps you could type it into Q&A. It might be a little easier for us to answer the question that way. And I myself, thank you very much for this information, great information to have. And you've kind of made me realize it's been a little while since I've addressed my own personal details. So you've given me some food for thought that it might be time to go in and take a look at it and do any updates possible that might be needed. It sounds to me that it would be a great idea for people to be a little bit more comfortable about talking to their loved ones about their wishes, to make sure that those wishes are clear. Shirley, I had a quick question here for you.
Sure.
Can you expound upon the green sleeve? I had not heard of that before, and the importance of having it where first responders can see it.
So the green sleeve, it is important to do. And if you don't do it, what happens if you go into the hospital, if you've had family members that have gone into the hospital, parents, they make you do it then, right? So if you do the green sleeve in advance, all it is, it's like a healthcare directive. It's outlining what you want. So you want to make those decisions of what you want to have happen while you're still healthy and while you're still able. So, you know, decisions like some people find it very important. They don't want to be resuscitated. So you pick that within there. You pick what you want to have happen. So a big one, you know, life support. What does that mean? It can have so many different areas, so many different things can happen to you. So this document just allows you to be really specific in different medical circumstances. And it's important to pick what you want your end of life care to look like. I had a lady yesterday that said there is absolutely no way she's going into a nursing home. It's not going to happen. I said, okay, so what will happen?
Yeah, I think that's
over it, like what will happen. So the things you need to address and think of, you can say these things, but you need to have a plan in place. And so the green sleeve addresses your medical issues, and then the responders, they know to look for it. They know that's the first thing they'll do. They'll look on top of your fridge or in the cupboard or right near it, around it. They're going to look for that. Because as I said, the first thing is to do not resuscitate. So they want to respect that. If they don't find it, then they're going to do everything right to keep you alive. And of course, if you're in a car accident, they're not going to be able to access that. That's only if you're in your own home. So it performs a great function, but a limited one, because not everything happens in your home.
And how does one access the green sleeve? Where do you find it?
Okay, so you're going to do that with your family doctor. So you're going to let your doctor know that you want to do it. They order the form, and then when that's in, you're going to make an appointment with the doctor to complete it. And it's about an hour appointment. And the importance of completing it with the doctor as well is at some point, this is going to go online on the medical system. So if you are in that car accident, the responder will be able to bring your name up, look to see what your wishes are. There's some issues with putting it online due to privacy, and I don't know when or how they're going to overcome that, but that's the goal.
Well, and I suppose the benefit of discussing this with your doctor, arranging it with the doctor, is being able to answer questions, because the first thing that comes to my mind is what situation or circumstance do you want them not to resuscitate, and what situation and circumstance would you wish they would? So I think that having the opportunity to discuss
your doctor would have that, you know, would be able to help you through that. Some people do it on their own, or they try. They don't actually ever end up finishing it because they don't know what some of the terms are. So they
and probably a little intimidating having this sitting on your refrigerator where you see it every day.
Yeah, that's why I say you don't necessarily need to put it on top. Put it in a cupboard. Near it.
We've got a couple more questions coming in here, and Colleen did put her question in chat about what if you have a trust and guardian. I guess
so does she mean, so if you have a guardian for an underage child, then you're going to have trust conditions in the will for that child. Whoever you've appointed as your executor is going to manage that trust for the child. So the guardian would apply to the executor for whatever the expenses are. So typically that would be a known amount every month, but they can apply to the executor with receipts for, maybe going into a hockey camp or whatever. So then the executor releases those funds for the care and extracurricular activities of the child.
I think, the situation may be similar for older adults who may have some disability or have care, and their financial circumstances are in trust, perhaps.
Yes, that's not unusual for that to happen either. So to have trust conditions for older adults that may need the monthly amount, or there's different reasons due to disability or not being able to handle money.
Still beneficial to have the executor and the power of attorney and all those documents in place, I think.
Oh, yes.
Della is asking, please note that registered plans do not automatically transfer to the spouse unless they're listed as the beneficiary.
Yep. So you name your you will, if you've got your spouse as your beneficiary, then it's seamless, it's smooth. If you don't have your spouse as beneficiary, then you have to go behind the scenes and get that all done, because as the spouse, you're entitled to it, but it's not quick or seamless then.
Pardon, forgive me here, but did we answer Maureen's question regarding the will being partially holographic?
Yeah, I did. I don't know what she means by, you can't have a partial holograph. It's either holographic or it's not.
I'm wondering, sorry to interrupt, I'm wondering if she means partly handwritten and partly typed.
Yes, you can do that.
Yeah.
Okay. And Maureen, if you need any further clarity, then just let us know here. Patrick is asking, can you comment on choosing executors, power of attorney for people who do not have children? How much younger than myself should a person be? How trustworthy are businesses that offer such service? Yeah, so that's the thing, is I suppose you want to make sure that you're selecting someone that's going to outlive you, presumably, and have the opportunity to look after.
Yes, exactly. So if you don't have those people, then we have Concentra Trust. So the credit unions own Concentra Trust, and they will perform the executor duties or the enduring power of attorney duties, not the personal directive, because as that states, it's personal, right? So if they perform the executor duties, they're going to charge 4.25% on the first million, 2.25% on the next 4 million, and 1% on anything after that. So people will often say, well, I don't want to do that. And I don't really want a trust company doing it. Can I have the public guardian or public trustee? No, you can't do that. So the public guardian or trustee will only step in hardship cases, and then they are still going to go looking for somebody. They're going to look for, they'll do everything to avoid having that duty. So they'll look for relatives and try to get those relatives to do it. And if they end up doing it, they charge, and it's actually just as much as a trust company.
Going back to Colleen again, she's further asked, what happens if your trustee and guardian takes part of my money? Do they do all of the stuff?
So the trustee and guardian, so she's talking, okay, so the executor and guardian take the money.
Colleen, I might suggest, it sounds like you have some questions. We will be sharing contact for the team here following, and it sounds like you've got some questions you might like to ask, and it might be a good idea for you to reach out to have a chat. We will share that contact here at the end, so that you can get your questions answered, ask them perhaps a little more clearly. Janice is, my doctor's office emailed me the document so I could review and complete it. I guess the green sleeve she's referring to. Once I have completed it, I'm to make an appointment and review it with him. Then it is put in a green sleeve. the office nurse said that they have been insuring their patients aged 75 and older have this. However, with the current pandemic, their office is now insuring patients aged 70. So they've reduced the requirement. They're recommending, I guess, their patients have this green sleeve. So
Yeah.
So
not all doctors are, so it's good to hear that some are. That's great. That's what they should be doing. So that's
yeah,
great.
yeah, absolutely. I had not even heard of it until you brought it forward.
In the more rural areas, if you walk into a doctor's office, they'll have a sign posted. You won't see that. I haven't seen it in Calgary.
If Penny is asking if family conflict is the #1 estate problem, how do you then choose an executor? It's I think that's an age-old question.
It's if you have 2 kids, often people will appoint the 2 kids so that there's not problems. You can't do away with the conflict because people get upset. No, they do get upset. So say you have 4 kids, but 2 of them are going to be able to handle it. The other 2 are just, they're not going to get it, nor are they going to deal with it. Mm-hmm. Things like a letter of wishes that you attach to your will, explaining why you've done what you've done to hope to minimize some of the conflict. Not saying it will, but say, George and Joe are, they're financially aware, they're good with numbers and paperwork. I trust that they're going to do this properly for all of us. The other 2 of you, I'm going to have as my, my healthcare directive, because you're going to look at the soft side of things. What you're going to think of my health, more of the finances, whatever that is, you can put in a letter, and hopefully it will help. And it's always tough being executors.
Yeah, and I will just add that for this very reason, we often encourage our clients to let us help them host and facilitate a family meeting. And so it is very common where we will have mom and dad, their children, and sometimes even adult grandchildren. And especially when it involves blended families, it's very important to have that dialogue, that discussion ahead of time, so that your loved ones are aware of your wishes.
Katrina, that's a great suggestion, great thought there. I was kind of thinking that as you were the presentation was going on. It sounds like it would be to a benefit to have a team like yours, and not only beforehand for planning, but afterward to perhaps help to guide the executors, particularly if they're your children, to be able to guide them through the process.
Yeah.
But I think, again, it's that making it clear of your wishes, and these are your wishes that the executor, the children are dealing with, and not one or the other making the decisions. So I think it's important to be able to talk to your loved ones and let them know what it is. And if you don't feel comfortable talking, I guess put it in writing so that they have clear direction. Christina is saying, from all the topics mentioned, what are the main differences for married couples and common law? Any suggestion of any paper or book we can read about this?
So with regard to the will, I would take it you mean. So if you do the will, right, so then you're going to leave everything to each other if that's your wish. So if you're common law, you're taking away that obstacle, because if you've done your will, you're leaving everything to your common law spouse. If that's what you want, then you're not leaving it up to whatever. And typically people have joint accounts, so that just is seamless. It just transfers to the survivor. So however you've got that set up, but that becomes the importance of doing a will, so that you're not leaving it up to chance.
Is there any kind of publications or website or anything that you might direct Christina to?
There's nothing that's coming to my mind that specifically addresses the differences between married versus common law, especially in Alberta. However, our team does have a number of different resources, an executor's guide, for example, and other literature that will help you through this process. And really, if you are wondering, if you have some questions about this, and in particular, if you're a part of a blended family, then I would strongly encourage you to reach out to our team and just come and have a chat with one of us, and we'll get you started from there.
Yeah, and in Alberta, we don't recognize common law. We recognize the Adult Interdependent Act partner, and that after 3 years, that becomes what we know as common law. But federally, it's still recognized after a year.
And again, Christina, I would encourage you, perhaps if you have any further, are looking for any further information, maybe to reach out once we've shared that information for you, reach out directly. Val, this is kind of, you're absolutely right. This is kind of old fashioned, but Val has said that her doctor is so old fashioned, he doesn't have a computer, so he can't access the health web. I don't know what you can do about that, but that sounds quite unusual at this in these times. Maureen, I understand that one should have only one executor with perhaps a backup rather than 2 or more, especially if those persons do not live in the same city.
Yeah, so you don't need to have, if you only appoint one executor, you do have to appoint a backup. So you have to name 2. If you name 2 as joint executors, then you don't have to appoint that backup. Yeah, it's you would want your executors, if you're doing it joint, to be near each other because they're going to have to do a lot of stuff together. So it wouldn't make sense to have one in, I don't know, one in Lethbridge and one in Edmonton probably, because that it would just make it cumbersome and hard to do. With executor as well, keep in mind you need to appoint somebody within the province. If you appoint somebody outside of the province, your state is going to have to post a bond to allow that person to deal with your estate. You can't appoint somebody outside of Canada, because then if you appoint somebody in the States, the executor is there, might be subject to taxes in the States, taxes in Canada. There's just all sorts of issues. So try to have somebody in your province. And if you're going to appoint 2 jointly, try to have them near to each other.
That's personally great information that I wasn't aware of. You know, my circumstances, I have a son in Ontario and a daughter here. You know, so when choosing executor and doing personal directives and power of attorney and that kind of thing, you know, I've got one that would be here for immediate needs, but you know, with my son being in Ontario, I had not heard that situation about having to possibly appoint.
Okay, so Colleen, I'll just add to that. So if you do have a joint executor, in your case, one here and one Ontario, because you do have one here, your estate would not have to post that bond.
Oh, okay.
But it still would make it difficult. Your son would have to be here a lot.
Yes, yeah, no, absolutely. I know that life choices many years ago have come back to create situations that you don't think about at the time.
Yeah.
I've got a point from Janice. One of the best things my father did was discuss his will and the reason for his decisions when he updated his will after my stepmom passed away. He initially discussed it with my brother and I, and then my step siblings. This was a good lesson on what to do because we were all aware of his wishes and there was no discussion. So that's great. I see Jeff said that was very smart of your father to do that. Anyone else have any further questions here for our panel?
I'm seeing still 1 and 6 in the chat.
In the chat? Oh, gosh.
I'm seeing 1. Oh, sorry, 1 in Q&A and 6 in chat.
The one in Q&A we did answer regarding the more than one executor. I just hadn't cleared that one out yet. Okay. And so. And I think we've answered the ones in chat as well.
Okay, perfect.
While we wait to see if there's any last questions that roll in, Katrina was just going to make some final comments here.
Sure.
Yes, so I just wanted to thank everybody for joining us today for this first webinar in our new series, Special Considerations for Seniors. Please let us know if you'd like more information about some of our future webinars. The next two that we have planned are Enhance Your Legacy, which Jeff teased a little bit. This is going to go a little bit more in depth in regards to some insurance strategies or strategies using some alternative means for charitable gifting, estate bonds, things of that nature. And then the next one will also be impact bonds. And this is going to look at conservative investment options that are maybe alternatives to GICs, you know, in this low interest rate environment. Some alternatives that also are socially responsible or can positively impact the world around us. So if you'd like more information, by all means, please let Stephanie know. We thought, just to keep things simple, that we would use Stephanie as our primary source of contact, and then if there's something for the rest of the team, she will let us know. So please, by all means, reach out to Stephanie. Her email address is up on the screen, and Colleen will have all of our contact information as well. So once again, thank you very much. If there's any questions that you think of after the presentation that you didn't have a chance to ask, please reach out to us, and we'll do our best to speak with you one-on-one to address that.
Thank you. Thank you very much. We look forward to those future presentations. I've got a quick question here from Vi. What is an appropriate compensation for an executor? I have 2 other children who have agreed on my choice of executor.
Okay, so an executor they can charge up to 5% of your estate value. There's a sliding scale, but the top end of it is 5%. So whatever your estate value is at the time you pass away, they can charge up to that amount. So executors often don't. If it's family, they may charge something, but they may not charge the full amount. Or you have a choice of putting what you want them to receive right in your will, and that is what they'll get. So sometimes executor fees can get way up there. People can make a fair amount of money if they claim the full amount. So say you don't want somebody getting $250,000 because you want that to go to your kids, then you could put right in your will you wanted them to get $25,000 as an example, and that's what they get.
That's good to know. Anyone any further questions here before we wrap things up today?